For the next panel, it's my pleasure to introduce Magistrate Judge James Orenstein from the Eastern District of New York, who many of you have heard of and who made headlines for his ruling in an Apple Computers case. Bloomberg News' Christie Smythe will join him for an interview on The View from the Bench. Please welcome Christie and Judge Orenstein.
Hello. I am delighted to have this opportunity today to speak with Magistrate Judge James Orenstein, who, as you all may know, has been issuing some very interesting and somewhat controversial rulings as of late, certainly causing some headaches for the Justice Department, which, of course, is always interesting. But just to briefly summarize his career, which is quite multifaceted, before joining the bench in 2004, right?
Yep.
He worked as a federal prosecutor on the John Gotti case and in the Oklahoma City bombing trials. He also served in roles in Maine Justice, informing, doing policy work and advisory work on death penalty cases.
Yep.
And later pivoted into commercial litigation and white-collar work at Baker Hostetler in New York. And all of those experiences have clearly informed his decisions on the wide variety of cases he oversees. And, but the reason why I'm especially excited to speak with him today, which is something I'm sure you've all heard about, is earlier this year he issued a very high-profile ruling in which he rejected the government's request to compel Apple to extract data from a locked iPhone seized in a drug probe. His 50-page ruling delved into all of the legal implications of the request and helped inform a national debate over privacy, national security, and smartphone encryption. So we're going to reserve some time at the end of the session just for a few questions from the audience. But first, I'd like to start with just some questions about the decision.
Okay.
What was the key factor that really drove your ruling? It's really quite a lot going on there.
Okay, and I should start off by saying, first of all, I'm not speaking for the judiciary or any of the judges or even myself. I guess I'm speaking for myself. And thank you all for having me and Christie for asking the questions. And I should also say, I actually was surprised when I got the invitation because I thought you all wanted the other James Orenstein, who's a prosecutor in Massachusetts and has had a great career. So I wasn't sure why you would want me. But anyway, here I am. So Apple, I'll quickly summarize the basics of the 50-page ruling so you don't have to read it. The government wanted me to tell Apple to help them open up a phone. They had already gotten a warrant to look into the phone, but they couldn't do it because it was password protected, and they didn't have the technological capability to get past the password. So they asked me to order Apple to do that under the All Writs Act, which is one of the very first laws that was passed in this country back in 1789. And I had two questions about that. One, does the act actually apply to this situation? And two, if it does, have you shown me what you need to show me to get an order under the act? The requirements for the act to apply is that it had to be in aid of the court's jurisdiction. Case law arguably, not even arguably, clearly says yes. I won't go into why that was sort of a left turn in the law back in the 70s, but now, yes, it's in aid of the court's jurisdiction to help somebody who's obtained a court order to get help vindicating its rights under the order. The second, is it necessary and appropriate to provide help? Again, the case law on that is pretty clear. It tracks a very broad phrase in the Constitution that's similarly broad. So I said, yeah, they could do that. But the third part of whether the act applied is this agreeable to the usages and principles of law, that wonderful sort of 18th century locution. And that turned out to be a really tough question, and I won't go into the pages and pages of analysis that got me to the answer, but the basic answer was it's not for a couple of reasons. One is it really upends the separation of powers between Congress and the courts and the executive if you can take a request for investigative authority that the executive has been interested in, that Congress has considered, and has never resulted in a law saying the government could do that. It would be a little odd to then go to a court, to one judge at the very bottom of the chain of command to say, oh yeah, you can do that. Even though Congress has considered it, decided not to pass legislation. And so that would be a real change in how we allow the government to do things. And particularly attributing that kind of authority to the All Writs Act would be unusual, I thought, because the people who passed it, that Congress, a lot of them, great number of them, were people who had drafted or ratified the Constitution, and the Constitution had that separation of powers doctrine written right into it. So for those and a number of other reasons I won't bore you with, I thought this really isn't agreeable to the usages and principles of law as the statute uses that phrase, and there's a whole other side of it, which is how you interpret a phrase like that has a few different moving pieces. So there was that, and then the second piece of it was, even if the law applied, is this something I should do? And there's a Supreme Court case from the 70s involving what was then similarly, recent technology about a pen register, something that tells you what numbers the phone has dialed. And the Supreme Court had said there that there are three things you have to consider. How close is the company to the investigation? How burdensome is it? And is this really necessary? And again, I won't bore you with all the details, but all three of those I found the answer had to be no. And as it turned out, after I made the decision, the last piece of it, is it necessary, was clearly not true because the government found a way into the phone right before they had to argue an appeal of my decision. So, sorry, that was probably a longer answer than you wanted.
Yes, they did actually get into the phone, so.
Yeah.
So to harp on one of those details,
Yeah.
you did find that it was burdensome for the company
Yeah.
to fulfill this request. However, in this particular case involving the technology at issue in this phone, Apple had previously used this similar process just to extract data. For some of the older operating systems for iPhones, the company has maintained some facilities as its headquarters to be able to get into the phone somehow. But in your case, you said you found that was burdensome. Can you explain why?
Yeah, well, first of all, I didn't just come out and say it's burdensome. When I got the request, and you have to understand, as a magistrate judge, I'm sitting there on criminal duty, and I get this request from the government. I'm only hearing the government side of it, and it's a sort of boilerplate 2 or 3 page request. So, I wanted to know, well, is there a basis for it? And I didn't see any reason why I couldn't find out what the other side of the story was. It wouldn't compromise an investigation. So I said, look, I don't know how burdensome it is, and there's no reason I can't hear both sides of the story. So before I make a decision, I'm going to let Apple tell me. And what they told me was, yeah, we've done this plenty of times. We've never really been asked whether we think it's burdensome. We do. Not in the sense of it's going to cost us a lot of money or a lot of man hours to do this particular phone, this particular case. But we're getting a lot of these requests, and it builds up, and it's not just unlocking the phone, then we might have to testify about how we did it in a later court case. That adds up. And then there's the basic issue of we're selling our customers a product that we tell them is secure, in part because of this password protection. What we don't want to do is break the product that we're selling, because that undermines confidence in our product. And frankly, we just don't think it's the right thing to do. So there's the burden of, you're asking us to do something we don't like to do. So yeah, they had done it before plenty of times, but it had never been considered in a court. And so when finally I considered it, I thought they had the better side of the argument.
Right. What made you decide to consider it and to take this up so vigorously?
Well, I don't know vigorously. I considered it. And look, anytime I get a request, what I should be doing is saying, do I have the authority to grant this? And if I do, should I? And that becomes more top of mind when it's something that's out of the ordinary. If it's a search warrant to do a physical search of a house, like, okay, I know what the Fourth Amendment requires, I know what the applicable rule requires, it's sort of a no-brainer. I know what the standard is, and I know how to apply it to the facts that I've got. But this was unusual, so I just started asking the questions that I think should be asked. And it's like you pull on one thread and it starts unraveling. I'm doing what I try to do always. It's just doing that in this case required or turned out to produce a longer, more complex litigation.
Yes, very interesting. In terms of this is not the only ruling you've had recently where involving a tech company, a government request for some sort of information or something, and then you've rejected it. You also had a very interesting ruling concerning subpoenas for Facebook customers recently. I don't know if you want to talk about that a little bit, but also just wanted to ask, do you feel a particularly strong sense of responsibility for helping draw the lines or making sure that those lines are adhered to when the government is seeking information in the electronic realm?
This may be a surprising answer, but no. I really don't, for two reasons. One is, my background is as a prosecutor, and I really get how important it is and how indispensable it is for prosecutors, particularly these days where so much information is committed to electronic data and third-party providers, how it's critical for them to be able to find a way into these receptacles of large amounts of data. So I get it, and so I'm not particularly trying to keep the government from getting it. And I also don't think I'm particularly interested, meaning more so than others, in drawing the line in surveillance or technology. But again, it's pulling a thread, and you see where it follows, where it brings you. I had one of these cases 10, 11 years ago, and that sort of got me thinking about the issues, and I pay attention to it. And so, because of that background, when the next one comes along, I might recognize an issue that jumps out at me because of that past participation. So, and I should also say, there are a lot of magistrate judges across the country who are paying attention to these issues and being careful to draw the lines. And it's never a matter, in my view, of policy. It's a matter of making sure that we, as the actors in the judicial system with the least amount of power, don't overstep our bounds by just sort of giving the government anything it asks for simply because they've asked. And we have to be particularly mindful of that, again, at my level of the judiciary, because so often we are only hearing from one side, and there's the inherent tendency to say, well, they're giving me a request and the argument sounds right, why not? What's the harm? In a way that others might not in the system, we have to think, well, what would the argument be on the other side?
Right. During this entire debate over encryption and the phones and so forth, Apple repeatedly said that Congress, not the courts, should be the place where this is ultimately decided. Do you have an opinion on how this issue will end up being sorted out and if it can possibly be resolved?
On the last one, I'm really not sure. And I don't know what the answer is. And in some ways, I feel lucky not to have to provide that answer. I mean, Jim Comey, the FBI director, has talked about this particular issue, encryption versus national security, as one of the hardest issues in government. And it's hard because it's not, I mean, look, even if it were just law enforcement versus privacy, that's a hard debate in itself. But it's not just that. It's really different sides of the same coin of what's secure, right? So there's the crime control interest in keeping us protected from terrorism and all these other things, where communications among the bad guys are encrypted. We need to the law enforcement needs to find a way into that, versus security on the other side, which is we all carry around these devices, we all entrust our lives to third-party data providers and internet service providers, and we need to be sure that trust is protected by strong security. So it's really security on both sides. As for the role of Congress versus the courts, look, we're a democratic society, and the least democratic way to get an answer to these hard questions is to ask a judge who wasn't even appointed by the president. I'm appointed by a bunch of other judges who are appointed by the president. So there's no accountability if I give the government this authority. And that's sort of how I read the All Writs Act, saying, it goes so far to help the judiciary do its business, but it's not a basis for a judge to say, never mind Congress, you can get this authority from me.
Right. One of the things that jumped out at me about your decisions is that you seem to have a lot of familiarity with technology. You seem very comfortable discussing it. You, I'm sure, are comfortable using it, seems like. I'm sure there are many other judges who are as well, but there are some judges in the federal judiciary and other places who somewhat brag about not even being able to use email. Do you think there's a danger in having judges who are not necessarily familiar with technology in everyday use when they are grappling with these kinds of decisions?
Look, we all have to be up to speed on modern technology because, as I look at it, we are living in the future. But here's my take on that. When I graduated law school, I was living in the same technological world, essentially, as when I entered kindergarten, right? And the judges who are making decisions and the legislators who are writing laws were doing the same thing. They were ruling and writing laws for a world they were familiar with. But because of this incredible technological advance over the last 20 years, we've got a generation of judges and legislators who are writing rules for a world that they don't know from growing up. And that disconnect makes it really hard to get at the right questions, let alone the right answers. By chance or for whatever reason, I've happened to have some of these cases come along that have forced me to get as up to speed as I can on some of this technology. So I try to do that. Not every judge has had the opportunity to do it. It's important to try and do it. But in that sense, I'm a tech-savvy judge, as someone called me recently. But the idea that I'm a tech-savvy anything is a source of no small amusement to my wife, who has to program the DVR and all that other stuff.
Right.
So,
Well, I don't know how to program the DVR either.
right. There are 3 remotes or 5 remotes, and I don't know which one to use.
We have an Xbox controller.
Right. I am a tech-savvy nothing. But by virtue of what has come through the pipeline for me to decide, I've had to get up to speed. And it really is true. Judges and legislators just can't say, well, I don't know from email. Mm-hmm. We can't make decisions in the modern world without getting up to speed. And if you'll indulge me, there are a couple of things that really come to mind. One is, I think a lot of judges and legislators try and think about technology issues by analogizing to the physical world, to the analog world. And what I've come across in getting up to speed myself is that it just doesn't work. These analogies always fail at some point, and it leads you to a somewhat technologically unsound view of the legal issues you're deciding. The other thing is I saw a case recently, an en banc decision in the Fourth Circuit, which was proceeding from the assumption that, well, we don't need to worry as much about, this is location data, or generally metadata, because it's not as informative as the content of communications. And there's, of course, a sense in which that's true, and that's how the statutes are written. Yeah. But there's research that shows that you can have a few data points that have nothing about communication, and you're going to know everything about a person's life. And that's, I think, a very specific example of where judges and legislators really need to get up to speed about where the technology has brought us so that they can ask the right questions and get the right answers.
Absolutely. So we're going to take a few questions from the audience, and I think there's a microphone that's going to be walking around. Does anyone?
That's technology.
Yes, exactly. Does anyone have a question? No? No
Excellent.
questions.
Okay, I've answered everyone's question.
No questions at all, because I can ask him a couple more. Okay. Go ahead. And if you please identify yourself as well when she brings the microphone
This
over.
proves to me that you actually did want the other Judge Orenstein.
Hi, Rochelle Renigal from White and Case. I'm very intrigued by your Facebook decision. I was hoping you could speak a little bit about that decision.
Okay, I was surprised. It got a little attention,
Yeah.
and that honestly surprised me. I thought it was a really, big nothing. So because so much information that law enforcement needs is no longer kept in your pocket or in your house, but in your, Facebook account and your Google searches and whatnot, a lot of times the government doesn't need a search warrant to get what they need. They can subpoena it from the tech providers that you give your information to. But that raises a challenge for them, which is that the tech companies are free, absent some ruling otherwise, to tell their customers, hey, we just got a subpoena for your account. There's a huge uptick in recent years in the government asking magistrate judges like me to order the companies that receive these subpoenas not to tell their customers. And there's a provision in the Stored Communications Act that says for tech companies, certain categories of tech companies, a judge can do that if the judge finds that disclosing the subpoena will result in the target of the investigation fleeing or destruction of evidence, the sort of things that you worry about if an investigation is disclosed. And what I said is, you're giving me a boilerplate application. I had 15 of them in one day. They were all verbatim. They all said, essentially, it's a secret investigation. The targets don't know about it, and disclosing this, could result in some of these harms. So give us the order. All I said was, you need to give me something about this particular case. Is this a subpoena for records of the target of the investigation, or maybe the victim, which sometimes happens? Just tell me something on which I can make the finding that the statute says I have to make. If you give me that, I'll consider it. But right now, no. And the other thing, and another part of it was that Stored Communications Act statute covers a lot of different kinds of ways that the government can get information. There's also a rule specifically about grand jury subpoenas that says you can't tell a grand jury subpoena recipient to be quiet. So there's a tension between those two, and I said, if you come back, you're going to have to help me understand how to resolve that tension, because it may be that what you're asking for can't be done in the context of a grand jury subpoena.
Any other questions? No others? Okay. Is there anything particularly about your background that you think is what you've done in your career in the past that has been particularly helpful in informing what you're doing now, from your law enforcement background or death penalty work, or?
Yeah, look, the death on the tech stuff and asking the kinds of questions that I asked about the All Rights Act, I'd say, or the Facebook subpoena case recently, it gives me an appreciation for what law enforcement is doing, so that I really pause and think hard about saying no to a government request. But I spent a year and a half at the Office of Legal Counsel in Washington, which is sort of like the internal law firm for the Justice Department, and it serves in a judicial role resolving intra-executive branch disputes. And you have to think very carefully about constitutional issues, and so that sort of primed me for asking some of these questions. And I should say I wasn't there in any kind of capacity. They get really the smartest people in government in that office. It's not well known, but they're really smart. I was only there because they decided a while back that they handle a lot of criminal law issues, so they want a knuckle-dragging litigator who does criminal cases to do a rotation through their office, and for 1 year that was me. But it really exposed me to a way of addressing issues and just asking questions that others might not think to ask. That has helped a lot.
Yeah. One more question. Oh, sorry. Go ahead.
I'm sorry, did you work with Merrick Garland when you were in Oklahoma City? And if so, can you comment on his nomination to the Supreme Court?
Yes and no. The question is if I worked with Merrick Garland when I was working in Oklahoma City. I know Judge Garland for many years. He had already left the team on the ground by the time I joined it, so I didn't work directly on the ground with him, but we interacted a fair amount over the year and a half, 2 years I was working on the case. He was sort of supervising it from Washington. He's a fantastic judge, a decent human being. You couldn't ask for a better person in the judicial capacity, which is where he is right now. As to what should happen with his nomination, that's for others to decide. I can't comment on that.
Maybe one more question? Can you go ahead? Can you say your name?
Hi, I'm Deirdre Heichel from Wilkie Farr. There was a lot of talk today about diversity in the profession and also about improving the experience of junior attorneys in their first 5 years. For litigators, both for women and for junior associates, those are people that studies have shown very rarely get the opportunity to stand up in court these days. Do you think there's anything that the judiciary can be doing to try to influence the opportunities and abilities for women, minorities, and more junior lawyers to get opportunities to stand up in court?
Sure. We can pay attention to those issues when we're selecting interns and law clerks. That's the easier part. But the only break on that is, we can pick from among those who apply. So we can get involved in recruiting to some extent, reaching out to the law schools and saying that's important, and there are programs where judges encourage that, and I've selected interns that way. So that's one thing. Another thing, and this isn't something where I can really take much action as a magistrate judge, but at the district judge level, certainly, there are opportunities to select receivers and special masters and other ways to appoint counsel or to select lead counsel in class litigation. And I've had some role in that in some cases, where you can ask questions about, how will you represent, how do you encourage diversity and giving junior litigators a chance? You have to be careful about doing that because there isn't necessarily a comfortable fit between those questions and the questions that come up in selecting the firm, but it's not an entire disconnect by any means. So those are ways I think the judiciary can help.
I think we're out of time. Thank you so much. Thank you so much, Judge Orenstein.
Thank
Really
you all for
appreciate the
having me.
opportunity. Great.